Now back to the show. This is You and the Law with Sterling Fox on AM 650.
Welcome back to the program. On this episode of You and the Law, David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver. Executors and administrators is the theme of today's show with our Vancouver estate litigation lawyers in studio. We're talking about the executors and who should become one and how that person gets appointed, what happens if a person dies and there's no will, and how the execution of the estate gets handled by an act in British Columbia that covers that contingency. But Ian, start us off here quickly, if you could. Talk to us about the job description, the executor. We've talked about, David's mentioned, for example, one of the things you're going to have to do is the books. After someone dies, there may be creditors and there will be assets. Maybe you got to resolve all that. Is that job one for the executor?
Well, okay, so a Coles Notes overview.
Sure.
I'm showing my age, Coles Notes.
Oh, I love it.
Overview of what an executor has to do, or an administrator without a will, is they have to ascertain the assets of the estate. They have to obviously apply for probate or administration to get recognized officially. They then have to bring in the assets of the estate. Now that may involve leaving assets in specie and in the form that they're found, but often they're bringing them into an estate account. The first thing they have to do is they have to pay the liabilities of the estate.
Right.
So any tax obligations to Revenue Canada, any creditors out there, mortgage, pay out the mortgage, or at least if you're selling the estate property, paying that out as part of the sale process and so forth. And then at the end of the day, you should have a net estate that can be distributed according to the instructions under the will.
Okay.
And all along, you have a duty to account. You have to either pass your accounts before a registrar of the Supreme Court, saying this is what I brought in, this is what went out, and here's the distribution to the beneficiaries, and
everything has to balance out to zero.
All works out to the dollar.
Okay.
And here's the fee I would like to claim. And by the way, I had to retain an accountant to help me with the tax and a lawyer to help me with perhaps probate or some other legal issue that arose. And I want all of that recognized in the passing of my accounts. An alternative, and one that's often used, is that the accounts are simply presented to the beneficiaries. And they're asked to review them and to approve them without the need to pass them before the court.
Okay, and if everybody agrees, then that's done.
Right, and there's a great advantage to doing that because if the executor or administrator is put to the task of passing accounts before the court, it usually involves hiring a lawyer to assist with that. And there's cost involved, time and money involved in
just being in
doing
court.
that.
Absolutely.
And of course, that an executor is essentially allowed to be compensated to be whole for taking on the job. So, any cost involved in passing the accounts will be borne by the estate. So long as the accounts look regular, there's a good incentive on the part of the beneficiaries to approve them.
Okay. Now, one of the first tasks in terms of getting permission to go forward with all of this, getting the probate document, one of the things that you have to deliver to the court in order to get this green light to go forward is the original will. So, David Hobbs, what happens when there's no original will? This all of a sudden becomes a bit of a sticky wicket then, doesn't it?
Well, some of the things that happen, Sterling, are that if you can't find the original, you might be able to obtain probate with a copy of the will, but you're going to have to prove certain things to satisfy either the registrar of the probate registry or a judge that it's appropriate to probate the copy.
Okay.
And
it's doable, but it's a bit of a dance.
Yeah, you have to spend some time and money and provide evidence and go through a process to do that.
Okay.
But another interesting related discussion is, what if someone says the reason you can't find the original will is because the deceased during their lifetime destroyed it. And destruction of a will is evidence of an intention to revoke the will. And it's actually a presumption in certain circumstances and so now you have a person, and the reason the person says that is because they'd like there to be no will, because under the Estate Administration Act, they take a gift, whereas under the will they get nothing. So they would like they'd like to move the goalposts into a no will situation. So we deal with situations where there's people trying to prove that the will's been destroyed, and people trying to prove a copy of the will, and so on. That's why you want your will in a safe place, and you want it. That's why we have wills notice searches. I mean, one of the reasons you search for wills after a person dies is to make sure they didn't make another one.
And that happens too.
Yeah, so you're in effect verifying that the one you have is the last one, in part by the fact that there's no notice of a more recent will.
And so that's the law, is it, guys, that the most recent document overrides any preceding documents?
A will revokes an earlier will.
Okay.
And typically they say that's the first thing generally said in a will is, I hereby revoke all prior wills.
Okay. Ian, you talked earlier about applying for a will's variation. This is work that you and David do all the time.
Right.
What is a will's variation?
Okay, so a will's variation, there's an act in British Columbia, a written law called the Wills Variation Act. And spouses and children, which include common law spouses and adopted children, they have standing to bring an action, a legal action before the court, saying the will of my parent or my spouse did not adequately provide for me. And so I'm seeking a court's order to vary the will in my favor.
To change.
Right,
Okay.
exactly.
So they're just a will's variation is an application for a change.
Right.
Have the court rewrite the will.
Are they usually successful?
Most wills variation claims settle, I would say.
Oh, okay. Rather than being adjudicated and a judge awarding something, the estate, the members of the beneficiaries resolve it.
Right. And there's good reason for that, because you control the outcome. The parties with the vested interest in the will and in the variation claim remove the risk of putting the issue into the hands of a third-party decision maker.
Who may give all or nothing as a decision, right? That's pretty high risk, isn't it? So if you can resolve it amicably, or at least amongst yourselves, somewhat amicably, better that than maybe risking nothing.
Yeah, I mean, we've seen all sorts of situations, but I mean, and typically with these families that are second marriages and spouses competing with children of other marriages and so on, the will may make a disproportionate distribution, and so either the child or the spouse will complain and ask the court to vary that will to make it adequate for them.
A couple of words that come up in the conversation when we're talking about wills and estate resolutions and disputes are caveats and citations. Let's take them one at a time. Ian, what's a caveat?
A caveat is a document, just a one-page document usually, or depending how many grounds you set out for the reason you're filing a caveat, but it's a person who has an interest in an estate filing a document with the probate registry of the Supreme Court, and the effect of it is it tells the court, do not process a probate application without notice to me, but the real effect is that probate will not be issued so long as that caveat is in force before the court.
Oh, okay.
And usually what's going on is it's being filed because someone believes that the will that the executor is trying to probate is invalid.
Okay, so caveat emptor is the only, I'm thinking old high school Latin, let the buyer beware. So caveat is beware. There's something wrong here. I'm filing a document that says all is not right with this will, and I'm here to dispute it right from step one.
Right.
Okay, that's a caveat, and that has to be filed with the same registry where the probate was filed?
Actually, a caveat can be filed in any Supreme Court registry in British Columbia.
Okay.
And they have a process whereby they notify the Victoria registry, and it goes out to all, so that all registries are aware of the fact that a caveat is being filed.
So when you guys, when someone comes to Hobbs Giroday, David, with a dispute, I mean, we don't even know the details yet. All I know is already I'm feeling underwhelmed by the outcome, and I'm not even sure what it's going to be. Would that be enough grounds for that first person to file a caveat saying that there's something really dodgy about this coming down, and I don't think you should pay too much attention to it?
Well, you have to, in the caveat, you declare what your interest is in the estate, because you shouldn't be filing a caveat if you have no interest, no possible interest in an estate.
Okay.
And it usually declares why you're filing the caveat. You think the testator lacked capacity when they made the will. You think the will was procured by fraud. You think whatever you think. You usually express that. But it's just a paragraph. It's not a chapter and verse of
Right.
whatever your theory
But
is.
you're saying beware.
This is who I am. I have an interest in this estate. I have a concern for the following reason. Goes to the registry. The registry, it's a red light. They won't probate that will. They'll tell all the other registries, don't probate the late Mr. Smith's will. And the whole process stops. And then we could go on to talk about how it might start up again and so on. But you stop the issuance of the grant of probate and therefore stop the executor from functioning.
Okay, and it's caveat, not caveat. Ian?
Well, I think either pronunciation works because I use both of them.
Okay.
But I just want to add that, when David talks about you must have an interest in the estate, it can be something like I would take under an intestacy, and I don't think this will is valid for some reason.
Oh, okay.
Or I take under the second most recent will, and I think the most recent will, the last will that the deceased made, is invalid for some reason.
Oh. Okay, so you've got dueling documents almost, or you're creating that kind of scenario.
Right.
Yeah, usually it's usually someone who would like an earlier will and doesn't like the last one,
right.
or someone who'd like no will.
We'll find out more about caveats or caveats and also citations, whatever on earth that may be, when we continue with David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver here on You and the Law on AM 650.
There's more of the show still ahead. This is You and the Law on AM 650.